So, Robert, you've identified in your statement what you have described as the principles which should underpin a compensation scheme. And if we could just look at those, if we can have the report back, Lawrence, page 60. And you set out there in paragraph 4.75 a range of principles. Remedial respect for dignity. The scheme must restore and preserve applicants' dignity and treat them with respect and confidentiality. Collaborative. The scheme should be collaborative with and supportive of applicants, and so far as possible avoid an adversarial approach to claims. Applicants should be believed unless the contrary is proved. Choice. The scheme should respect and enhance the autonomy of applicants, including offering a choice of how remedies are delivered. Individualised, reflecting individual circumstances and experience. I may come back to that. Inclusive. The non-technical. Should be no bar to eligibility based on technical issues. Accessible, readily accessible, understandable, free of complexity and stress. Ease of proof, unjust, distressing and disproportionate requirements of proof and evidence should be avoided. And then broad, improving, no claimant for compensation should be worse off than they would be without such a scheme. And then over the page, complementary, the continuing payments under the existing support scheme should be continued and made more secure regardless of any claim for or award of compensation. And then holistic, compensation not just about money but should also include consideration of material means to compensate for what has been lost. Would it be right to understand that particularly the reference to respect, collaboration, choice, accessibility, ease of proof and so on, that those principles have been identified by you because they reflect some of the problems or concerns or unhappiness that those infected and their families have had in dealing with schemes over the years?
Yes, I received, I think, strong messages about all those matters in the submissions and information given to me. And I think what I was trying to do here was partly to synthesise that, but also the very helpful submissions I received from some RLRs, which appear in the appendix. The order, I'm afraid, is not that. If you ask me about the logic of the order, there might not be one, but I think they're all probably important features. But it's a very particular, and it's part of the moral case too, I think. It's a very particular feature of what I was hearing that people had gone through, that they felt there'd been a lack, their respect for them was significantly missing. Their ability to choose things had gone. They've lacked information. All these things, it seemed to me that there was a risk that any scheme of compensation could actually make some of those things worse, and so it was very important that it shouldn't do that, but actually should do the opposite.
And then a suggestion of an additional principle that I've been asked to explore with you is the requirement that the scheme be properly funded. Whether it appears here as a principle or as some other facet of the scheme, to try and avoid the difficulties that have arisen with previous incarnations of support schemes where there's been uncertainty over continuity of funding, difficulties for the schemes themselves sometimes in planning. How important would you regard a requirement that the scheme be properly funded?
Well, obviously it's extremely important, and it is the implicit underpinning, if you like, of everything else I've recommended in terms of awards. It appears to be the case that some of the previous schemes have suffered through limitation of funding, in the sense that a lump sum is provided and the struggle has been how to distribute that. This is starting the other way around, the compensation scheme, which is that people will be eligible for an assessment of amounts which are to a large extent capable of being judged objectively. Clearly, that doesn't work if the funding is not available to that. And I appreciate that probably means that funding has to be, to some extent, open-ended, and obviously estimates will need to be made about what is required and when. But in just the same way, if I may put it this way, that NHS resolutions administration of the damages schemes for the National Health Service is, in a sense, an open-ended budget, in that they have to pay whatever is determined by way of settlement or award in damages claims. Any arm's-length body for this scheme would require a similar approach to funding. But in a way that's, I mean, without that, you can't have a compensation scheme.
We can close that for the moment, thank you. Now, your terms of reference provided that the study should take into account differences in current practice and or law in the devolved nations.
Yes.
I think in practice, perhaps the most discrete area of law where there's a difference between some of the principles you apply would be in relation to Scotland. I want to come back tomorrow and deal with certain particular issues relating to the approach to damages in Scotland. But in broad terms, would it be right to say that you have drawn more from the approach to awarding compensation in England?
Yes, I think that's fair. And that may be either a strength or a weakness, whichever you prefer to see it. But I think the overarching that would be a message that the compensation awarded should be, subject to individual circumstances, but the same principle should be adopted whether you're in England, Scotland, Northern Ireland or Wales.
And then in terms of other compensation schemes, you've referred obviously to the scheme in the Republic of Ireland, you've referred to the September 11 Victim Compensation Fund and the Criminal Injuries Compensation Scheme. You've explained in your report that you had access to both, I think, a textbook which looked at compensation schemes around the world, and then there's a summary of some of that in a PowerPoint. We don't need to put it on screen, but the reference for those who want to look at it is SRFS 602. Were there any other particular compensation schemes or features of compensation schemes elsewhere in the world that struck you as either particularly useful or something that should be avoided?
Well, the textbook which you mentioned was really helpful in giving me a sort of world view of compensation schemes, and is well worth a read if you're interested in such things. What came through to me was that all compensation schemes are different, and they all arise out of a social, legal, and maybe sometimes a political context. So schemes, for instance, that are often referred to when we're talking about compensation here tend to be New Zealand, some of the Scandinavian countries. When you actually look at those, they do have many features which I think would accord with the principles I've put forward. But a lot of them, particularly, say, in Sweden, are there because they are run and supported by a sort of structure of insurance companies and so on. And this is a way of bringing together the obligations of insurance companies, the liabilities of the state and so on, which isn't quite where we are here. So quite a lot of schemes, it seems to me, have an origin. And so in New Zealand, they brought together, they now have a scheme which has brought together various streams of compensation from all sorts of different areas, motor insurance as well as medical and so on. And so lead to something which perhaps becomes even more complicated, I might say, than what I'm recommending here. So the ones I picked, and it is obviously a subjective selection, I thought were illustrations of some of the good things about schemes, but also some of the challenges. The one you haven't mentioned, and I haven't just mentioned yet, is because it's still topical, is the Windrush scheme, and the Home Affairs Committee's report about that, which I think is a very useful reminder of the difficulties that can arise in relation to schemes if they're not very carefully thought through in consultation with the people who are intended to benefit from them.
Now, I want to turn now in more detail to some of the specific recommendations. I'm going to start with recommendation 2. And recommendation 2, if we just go back to... I've managed to pluck out the relevant pages of the recommendations. I think it's about page 30-something. of the report. So try page 33 now. Thank you. As if by magic. So recommendation 2 was the scheme offering redress to those infected with HCV and or HIV. I obviously don't propose to ask you anything further about the inclusion of those. And then defined serious cases of hepatitis B. And I just want to ask you a little more about hepatitis B. If we go to page 62, please. Under the heading Conclusions on Coverage, you explain your reasons for approaching hepatitis B in the way that you did. So you said, of necessity, this very generalised view of the impact HBV can have is based on a reading largely of the expert evidence to the inquiry. It's not a subject which the infected raised at our meetings, although I have been pressed in written submissions to include HBV infections as a category of eligibility. On the basis of the description of HBV and its effects, which I hope is a fair one, I'm unable to recommend that this infection be included in a compensation scheme as a separate category with one exception. I consider a number of factors distinguish hepatitis B from hepatitis C. And then there are 4 bullet points there set out. The first was that generally the effects of hepatitis B, while it may be a long-lasting infection, are mild or even non-existent so far as the impact on the quality of life of the infected is concerned. Compensation in such cases would be likely to be low. It's possible the cost of processing claims for it would be disproportionate. 2, there is available effective treatment which is likely to suppress the disease and avoid the more serious consequences with regard to the liver. Many cases where there are more serious consequences are likely to be where there's HBV with hepatitis C or with HIV co-infection. And then your last bullet point, in the absence of the more serious infections, it may be difficult to establish causation. And then your exception is set out in 4.85, those who develop a chronic infection with serious symptoms who require treatment to prevent cirrhosis or who have actually contracted cirrhosis. So is it right to understand that those who fall within paragraph 4.85, you would recommend that they are compensated within the framework of the scheme?
Yes.
And then I think only fair to you to point out that in 4.86, you say the inquiry will have been able to consider more evidence than you have, and you would recommend your conclusion be reviewed in light of the inquiry's findings.
Well, can I also say, and this particularly because I looked again at the expert evidence or the report, and it seems to me, and I may be wrong about this, that no one has actually asked the expert to distinguish, but they've described things, but they haven't actually done an exercise of distinguishing one from the other. And I think that makes what I've said here even more conditional in effect. And obviously what I've said here is on the basis of what I have read and my understanding. I had, no doubt I could have thought it, but in the time available, it would have been difficult. I sought no independent expert advice of my own, and I actually thought it would probably confuse things if I did. And so
just before we look a little more at hepatitis B, and I'm just going to ask you to look at some passages in the inquiry's hepatitis expert group report that court participants have asked me to flag up. But before we do that, could we just go back to page 17 of the report? And it's just to pick up a potential omission in the executive summary. So bottom of page 2.13, conditions for eligibility for the directly infected should be. And there we've got the reference to hepatitis C and HIV, but not to hepatitis B. Should we understand that hepatitis B of the more serious character should be included here?
I had picked that up myself. Actually, it is an omission. It should be there.
And then, did you have available to you when you were considering the issue of hepatitis B any evidence on the psychological impacts that may be associated with infection with hepatitis B?
Only insofar as it was mentioned in the there's a psychosocial expert report.
And then if we can look at just a handful of passages in the...
and can I just add to what I didn't have was that, as I say in the report, none of the people I met actually brought forward hepatitis B as something to consider. So that didn't mean I wasn't going to consider it, but it was I thought that was noteworthy.
And again, perhaps feeds into your suggestion that the inquiry,
Yes.
which will have had more evidence,
Yes.
may be able to deal with it in more detail. But if I might just ask you to look at just a handful of passages in the expert report to the inquiry from the hepatitis group. It's EXPG 601, please. And so, Robert, I know you've read this. I'm just going to highlight a handful of passages which core participants have asked me to raise, and then just ask you a couple of further questions. So if we go to page 3, please. The paragraph, just above paragraph, or question 15.2, so we see there, HBV and HCV are the most important causes of viral hepatitis globally. Each can range in severity from very mild, where an individual has no symptoms and no long-term consequences, to being so severe that the liver can no longer carry out its essential functions and fails with a high risk of death, sometimes necessitating transplantation. The key concern with long-term HBV or HCV infection is progressive scarring of the liver, fibrosis leading to cirrhosis, and an increased risk of liver cancer, hepatocellular carcinoma, HCC. And then the second paragraph is, if we pick it up at page 60, it's probably page 64, Lawrence. I've not got the electronic pagination. Yes, bottom of the page. This identifies some information about hepatitis B that the expert group said should be provided to newly infected individuals. So basic information on what hepatitis B is, different stages of infection, what effect it can have on health, including increased risk of liver scarring and liver cancer. So I'm asked to flag that up. And then over the page, the transmissibility of hepatitis B is a point I'm asked to identify. And then I think it's 5 bullet points down, the fact there is no cure, but that long-term medications are available and might be recommended. And then the penultimate bullet point, the need for regular attendance at clinics to monitor infection. And then if we go to, it's page 66. So no, over the page, sorry, Lawrence, if we can go to the next page. So again, we see under the reference HBV there, the reference to the risks of sexual transmission. And then, if we go to, I think it's page 73. Should be internal pagination. Oh no, can we go back to the previous page? I'm sorry. So we've got there at the bottom of the page, this is impact, for example, on fertility. So for those living with hepatitis B and hepatitis C who develop advanced fibrosis/cirrhosis, fertility is reduced and pregnancy is uncommon. And then there's further discussion of that. I don't think I propose to read those aloud. And then page 80. Under the heading Supplemental Question 26, the first paragraph, which begins the details of individual treatments. So that refers to tenofovir, TDF as the first-line treatment, in discussions with patients as to the need for follow-up and monitoring, it would be expected to include consideration of potential toxicity to the kidneys, the need for blood and urine monitoring. And then bottom of the page, there's a question about guidelines for infection control, and I'm asked to flag up to you that the precautions in terms of transmissibility apply to both hepatitis B and hepatitis C. So those are some of the points in relation to hepatitis B, Sir Robert, that I've been asked to draw to your attention. Before I ask you further about hepatitis B, it's also right, I think, to note that in terms of that sense of injustice that you refer to as part of the moral case, those infected with hepatitis B have never been part of any scheme thus far. So they've not had any of the payments that those infected with hepatitis C or HIV have had. I'm asked to suggest to you, Sir Robert, that the differences between hepatitis B and hepatitis C that it might be said your report reflects are illusory, that essentially hepatitis B should not be regarded as something which is quintessentially a much milder or less alarming condition to suffer from.
Well, I understand entirely what you say. I mean, I would point out that in relation to cirrhosis, fibrosis, and liver failure and so on, those are very much the cases in which I envisage there would be an exception. I must say I did take into account the fact that there had been no previous coverage for hepatitis B, and therefore what I said about a moral case in relation to past statements and so on, and the public reflection of a moral case for HCV and HIV doesn't seem to have been perceived before. Now, I think all I can say is at the end of the day, a value judgment has to be made. If you go down the route of a moral case, which is what I suggested should happen, and the issues you raise could result in including hepatitis B. If it is felt, and maybe that's something the expert panel could be asked about, there is in fact no realistic distinction between the two. It was simply my reading of the evidence that I read was that there did seem to be the distinctions I've identified. If that's not the view that is generally taken, then maybe that needs considering. What I would point out is that to set up a compensation scheme to remedy injustice is an exceptional measure, requiring, and what I'm suggesting here is a significant broadening from what would be legal liabilities, and therefore a judgment has to be made whether there is a boundary around that in terms of proportionality. I've sought to suggest there might be a case where that is so, but clearly my view is not determinative of that issue.
Can I then pick up on VCJD? And if we go back to your report, please, if we could have that back on screen, Lawrence, at page 63. You say there at paragraph 4.89, this, a number of infected persons have received written warnings that there's a risk of their having contracted VCJD. However, the distress and suffering caused by being informed of the risk of contracting this disease is not compensatable under the VCJD scheme. This is a risk shared with all those who have received all relevant blood products, whether or not they've been infected with the principal infections with which my terms of reference are concerned. Therefore, I suggest that apart from the extent to which the general concern about the risk of VCJD applies to all infected persons otherwise eligible for compensation, this disease is left out of account in this scheme. Can I just explore with you exactly what's meant there? So somebody who is not infected with hepatitis C, not infected with HIV, not infected with hepatitis B, but has acquired no actual infection, but has been informed that they might be at risk of developing VCJD. That category of person you are not recommending for inclusion within the compensation scheme.
No.
But if you have someone who has been infected with hepatitis C or HIV or the more serious category of hepatitis B that you do bring within the scheme, so they have a real experience of the trauma, the suffering that comes with infection, if that has been compounded, particularly in psychological terms, by being told that they are at risk of VCJD. And I should say the inquiry has heard evidence of those who have been significantly psychologically affected by that additional burden of the knowledge of risk of VCJD on top of everything else. Is that a factor that could form part and parcel of the assessment of the injury award?
Well, I think so. I think I start from the point that, and of course I may be completely wrong about this, the actual risks of contracting VCJD are very small indeed. And that's not to say, of course, being advised of the risk of it is not in itself a concerning issue, bearing in mind the gravity of CJD. But if we're talking, I mean, I'm not sure if you're suggesting that I ought to consider there is compensation scheme to everyone who's received a blood transfusion because there is that risk, because that would seem to be, if you did ask me that, I'd suggest that was disproportionate. In relation to those who have one of the eligible diseases, and let's leave it, the issue about hepatitis B out of that for a moment, then I think that the added information about VCJD could be taken into account because it's whether you look at it as an exacerbation of the suffering caused by you're actually looking at it as a relevant factor which makes the distress of having a concatenation of infection greater. And that is part of a personal circumstance. But I would treat that with some degree of caution because, again, I could be completely wrong. People may have received warnings about that risk, but it would appear to me that that risk must be extremely small indeed. So, objectively, whatever the distress that's being caused, these people are vanishingly unlikely to get that disease, particularly now. But I may be, that could be all misinformation or misunderstanding on my part.
Yes, and it's right to know the inquiry's obviously had the benefit of hearing from a number of individuals about the impact upon them as infected individuals, or upon their family members as infected individuals of having this.
But I would suggest that any assessment of, as it were, additional compensation to be paid for that does need to take into account whether whether that advice ought to be given and the terms in which it's being given. And if it's correct advice, of course, that's one thing, in which case has everyone received that advice, and if not, why not? If it's wrong advice, then I wonder whether that is something that's so specific that it shouldn't be talked about in the scheme. It's a complication, it seems to me, which probably requires more information than I have access to.
I just want to observe that this is a rather different sort of risk in this sense, that sometimes a clinician may say to a patient, if you take this, then there is this risk to you. The risk of contracting VCJD is retrospective rather than prospective. It's telling people, because of the treatment you have already had, you are now at risk.
Yeah.
And so there is that difference, which it may well be that I feel I should take into account. Your suggestion would be, well, this is something which aggravates the other conditions which they would suffer from.
That's my position. I appreciate this is a struggle and there's a balance, but there needs to be a distinction between something which is different for those who have been infected and those who have no infection but may still have been exposed, albeit retrospectively, as it were, it comes to light, to the risk of VCJD. One is a very large group of people indeed, and the other may be a very small one.
And then if we could just going back to hepatitis B in terms, again, I think of something that might need a mild correction in the report. If we go to page 69, paragraph 6.6, I think there says I've included that none of HBV, HCV or VCJD should be separate categories of eligibility. That, I think, doesn't entirely reflect your category of serious hepatitis B.
I think that's probably right, although there is a qualification in the following sentence which deals with one part of
Yes.
that.
Can I then turn now...
Actually, yes, I think that's right. The difficulty about HBV, and it seems to me, is that there may be a case for including it, certainly where it's a co-infection, but also where there are particularly severe cases, and that the latter bit is not included in that sentence and should have been, yes.
Could we then go turn next to recommendation 3? Can we go to page 33 first of all, please? So we can see recommendation 3. The first is just to point out what I think is a typo in 3A. It says they've been diagnosed as being HCV,
yes, that's
or HBV. So it should be HIV.
Yes. My apologies.
Now, I want to just explore a handful of issues relating to the conditions of eligibility for those infected. Could we start by going back in the report to paragraph 2.15, which is page 18? You say this in paragraph 2.15, where possible, eligibility should be automatic for those who have already been accepted as eligible for regular support by one of the existing support schemes or any of the preceding schemes. And then you go on to talk about how eligibility may be assessed for those for whom it's not automatic. It's the qualification where possible. If someone's already been accepted onto a scheme, whether for regular support or otherwise, should they not be automatically passported onto any new scheme?
I think that's what I'm saying.
So the where possible...
Well, I'm not entirely clear whether everyone who has been, whether it is entirely clear, for instance, for someone who has died in the past, whether they were accepted on a scheme or not. And we know, don't we, that there's an archive of information which is released only with some difficulty, from which things can be established. So where possible, I mean where it's possible to establish that they've been considered to be eligible, that's all.
So anybody who has previously been accepted as qualifying, whether it's under the Macfarlane Trust or the Eileen Trust or the Skipton or any of the devolved schemes, that should effectively be sufficient for establishing eligibility.
Yes.
And would you, and so the suggestion in paragraph 215 in the second line, it seems to suggest that this automatic eligibility should be for those who've been accepted as eligible for regular support by one of the existing support schemes or any of the preceding schemes. Now, the point I've been asked to raise with you, Sir Robert, is that might be unnecessarily narrow because it would exclude automatic entry for example, the bereaved who'd received a lump sum payment but no regular support because regular support's not an option under the current scheme for them. And I wonder whether it was meant to refer to regular support or not.
Forgive me, this paragraph, I think, comes in the section about eligibility for the infected.
Yes.
So that's what this is referring to, not the affected.
If we've got a claim on behalf of an estate, then...
Yes. Well, that comes under the eligibility for the infected.
So if we go to page 70... the point emerges because of what looked like a difference in wording between paragraph 215 and paragraph 613. That's the reason why I was asked to raise it with you, Sir Robert. Here you say entry to the compensation scheme should be made as easy as possible for all those infected persons who have been accepted as eligible for support by one of the existing or past support schemes.
Yeah.
So there's no requirement there that they have been eligible for regular support. If you had someone who'd been accepted, had only ever sought a one-off payment and not sought regular support, they would still be passported onto the new scheme.
I think so. That would be subject, I think, to a bit more analysis than I've conducted into what the eligibility for these schemes was. But I've assumed that in effect eligibility to those schemes was the equivalent of the tests that I had set out.
And would it be right to understand that you're not suggesting that anybody who has previously been found eligible under any of the existing schemes should now be regarded as ineligible?
As long as I've got the negatives right, yes. I agree with you.
Would you also agree that as much as possible in terms of the process of application, that it's important to avoid people having to repeat and redo past applications,
Yeah.
which may exacerbate current health issues?
I think it's essential that all the material that's been collected in the past is made available and taken into account by the new scheme, absolutely. Inevitably, I think that because whether my recommendations are accepted about impact awards and so on or not, it is possible that a wider range of information will be required from people to be able to assess the gravity of what they've gone through in a way which probably isn't necessary if what's happening is a regular payment, regardless of whether you would be moderate, severe or less severe.
So if we then go to page 68, please. We've got the heading there, eligibility criteria, and then the conditions set out at the bottom of the page, and going over to the next page. And
condition 1 needs a correction again.
Yes, for the serious cases of HBV. It's really condition 3 I wanted to ask you a little more about, which is paragraph 6.8. First of all, would it be right to understand, in light of what you've said about those previously eligible being essentially automatically onto the new scheme, that in terms of applying condition 3, that's really only going to be relevant to new applicants?
I think so.
Yeah. I mean, either completely new or those who were previously applied but were rejected.
Yes.
And then in the penultimate bullet point on the page, you have referred there to a defined period during which the administration of infected blood or blood products was avoidable, whether in light of the knowledge of the time or retrospectively subject to the relevant technology or science being available at the time. And then you say this: it's difficult to identify such a strong moral case for compensation for treatments received before, for example, HCV or HIV were known to exist. Firstly, the reference to HCV would presumably include, would it, previous descriptors such as non-A, non-B hepatitis or non-B hepatitis or serum hepatitis?
Yes.
And HIV would include AIDS, HTLV3 or LAV?
All those definitions, yeah.
There was a period of time in which there was a body of infections known as serum hepatitis, which later identification of the viruses which formed part of it showed to be a mix of largely what is now known as hepatitis B and what is now known as hepatitis C. There may have been other viruses as well, but they've not featured to any great extent. So, am I to read this as representing if it were known that serum hepatitis, that is, hepatitis transmissible by blood and blood products, was known, let us suppose from 1944 onwards, at least, then that would meet this test?
Well, that is one part of the test, though, because the other part is that it was avoided. It's one thing to know that a disease exists, it's another to have a means of screening for it in samples, which might be a different issue. So it's the two together, I would say. But
I see.
More broadly, the idea introduced in that bullet point of avoidability, how in practice Do you envisage that as a criterion being...
Well, I think the inquiry has received evidence, which I don't pretend to have analysed, about when the different screening technologies came in and how effective they were, and the ability, therefore, through testing either of donors or of blood or blood products, one could detect an infection.
So is it then right to...
So the principle behind what I'm saying is that is to avoid looking at whether there was a step someone knew about but didn't take at the time, as in negligence, and whether there was a technique available which could have uncovered this but didn't.
Just looking at condition 3 as set out in paragraph 6.8 as a whole, is condition 3 really concerned with what are the dates within which someone would need to show they had been treated?
Yes.
You're
But not by relation to what was the practice at the time, but from what we now know, but in terms of what was available at the time, could have been used and what could have resulted in the infection being detected.
and you're...
But you're right, that results in an identification of a date, which is probably going to be artificially precise.
But is it right, again, to understand that you're not suggesting by talking about avoidability, which is a phrase that appears here and a couple of other places, you're not suggesting, as I understand it, that individual applicants have to show an individual case of avoidability?
No, not at all. No, this is one of those things that needs to be determined in advance to apply to the whole scheme.
So it's really just what are the dates within which...
Well, it may be,
operates?
for all I know, that the dates of the current scheme of the IBSS are roughly right, but which are identified in the first bullet point. But it's actually belts and braces, because obviously this inquiry has more information than they would have had in setting those dates.
And I think I'm asked to point out that you're absolutely right in relation to the September 1991 date for hepatitis C.
Yeah.
But my understanding is there isn't a cut-off date in relation to HIV. There certainly wasn't for the Macfarlane Trust or the Eileen Trust. To the extent that there was a relevant date for Macfarlane Trust, it was tied to the making of claims rather than treatment. And my understanding is that there isn't a cut-off date operated by EIBSS. Or I think the other devolved schemes in relation to HIV.
In that case, I apologise for the error. But it seems to me a date needs to be fixed.
Can we then, may need to come back to that in due course, but can we then, just picking up on recommendation 4, so if we go to page 33 again, I think, Lawrence. Oh, 34, thank you. You're ahead of me. So recommendation 4 is about how to prove eligibility in a nutshell.
Yes.
And your recommendation there is avoid legalistic and adversarial concepts of the burden and standard of proof. Establishing eligibility under the scheme should either be automatic in the case of infected persons already accepted for eligibility under the support schemes, or be a collaborative process in which the applicant is sympathetically supported by the scheme in obtaining any required information and documentation. In general, a presumption is applied that statements of fact made by an applicant are correct. Applicants are not required to repeat information already provided to the support schemes. Eligibility is accepted if the information available points towards eligibility and there is no strongly persuasive evidence which contraindicates eligibility. So the process that you there describe for those who are not already accepted as eligible, is that in part designed to avoid the difficulty that may be created by an absence of medical records and thus an inability on the part of an individual to point to a record and said, look, I had a transfusion on such and such
Absolutely,
a date?
yes. And so obviously there are going to be cases where that is the case, and inferences are going to have to be drawn from circumstance, and the scheme has to start from a point that a lot of people may have great difficulty in getting information together. I should say that I was particularly impressed by what I was told about the Scottish support scheme and how, in certain respects, in effect, they simply accept what the applicant tells them. And while that might be surprising to some lawyers and some and perhaps some people in government, it seems to work very well. They tell me, and there is no instance of fraud. People genuinely tell them the truth. So that, which is the trouble with so many schemes, frankly, is that the battle people have to persuade the grant-giving authority, if you like, that they come within it, makes the damage even worse. So that's what I was impressed by, and that's what I try to reflect here.
And if we go back to paragraph 2.15, which was your summary and the executive summary on proof of eligibility, page 18. If we just zoom in on paragraph 2.15 again, if I pick it up a little further down from where I previously read, so the end of the fourth line, the search for supportive evidence should be proactively conducted by the scheme administration in collaboration with the applicant. Where possible, existing medical information should be relied on and assumptions made in favour of the applicant from surrounding information where direct evidence on a relevant matter is absent. And then this, you say, generally, the recollections of the applicant should be accepted as true unless there's overwhelming evidence to contradict them. Rejection of eligibility by a support scheme or absence of symptoms during any particular period should not automatically exclude an applicant. So the starting point is this, right? If an applicant is infected with one of the eligible conditions, let's take hepatitis C for present purposes, and they have a recollection of treatment within whatever the eligible window of period may be, your suggested approach would be the starting point is, well, believe them.
Yeah.
Unless there's some positive other evidence to suggest that that's
I'm not suggesting
case.
that when someone comes forward with the recollection that the scheme should be debarred from looking at the medical records that exist and other matters. But what I was seeking to suggest is that the scheme itself needs to be proactive in looking for relevant information and should be starting from the presumption that what they're being told is true. And so uncertainties, of which there will be many, should at the end of the day be resolved in favour of the applicant.
And the inquiry's heard evidence about historical blood use policy and practice to suggest, for example, that there were practices of topping up patients with small blood transfusions which might not be clinically necessary and certainly wouldn't be given by current standards. Would you agree that whoever's undertaking the assessment on behalf of the scheme must look at that historical clinical practice rather than contemporary clinical evidence?
Contemporary.
So rather than what the inquiry has seen some evidence of, particularly in relation to the Skipton Fund, is someone coming along, they don't have medical records because through no fault of their own, those records have been lost or destroyed. They said they have a recollection of a procedure in which they had a transfusion. There may be some evidence of the procedure, but often none of the transfusion. And clinicians looking at it now say, oh, well, we don't give transfusions for that kind of condition or that kind of procedure. That wouldn't necessarily be the right way.
No, certainly
to
not.
look
No,
at it.
the reference obviously has to be by way of what is known about what the practice was then.
Then can I ask you to look at it's paragraph 2.13, so top of this page should, I think, be... Yes, so it's the reference in the summary here of condition 3. Sorry, top of the next page, Lawrence, my fault. So in the paragraph number 3 at the top of the page, the applicant received the relevant treatment within or from stocks created within the periods of eligibility implied by the current support schemes. In relation to the reference from stocks created within, what is it that you had in mind there?
Well, what I was told was that there are some people, possibly a small group, who believe that they have received treatment, as it were, after what might otherwise be a cut-off date, but from stocks which are left over from a period within. That's what I was getting at. And I appreciate that trying to find that out might in some cases be very difficult indeed.
So that might again be a kind of example of where, first of all, the schemes should be proactive in trying to find what kind of supporting evidence might be available, whether from the transfusion service or the hospital. But assuming that kind of evidence couldn't be gleaned, that might be the kind of scenario in which it might be appropriate, as it were, to give the benefit of the doubt to the applicant.
Yes, I mean, I imagine the period is relatively small. I don't know, but I imagine stocks aren't kept on an indefinite basis, but I don't know that.
And then just going back to the issue of cut-off dates, is it right to understand you are not advancing any specific cut-off date because you haven't analysed the evidence in relation to that? You are simply referring to the fact that, at least insofar as hepatitis C is concerned, there is a cut-off date in the schemes, and a decision will have to be taken, whether informed by the finding of the inquiry or otherwise, as to whether there should be a cut-off date for the scheme you propose, and if so, what it should be.
Yeah, well, my reading, and of course limited by the qualifications I've given many times, is that there is a time after which, if I can put it broadly, when screening techniques and general knowledge and practice was such that the risks of infection have become vanishingly small. Thank goodness.
We can take that down. Thank you, Lawrence. The next question I wanted to ask you about is a category of those infected with hepatitis C who clear the virus within a period of time. You haven't excluded what are sometimes referred to as natural clearers from the scheme.
Certainly not. I mean, the fact they've cleared obviously is good news, but it is realistically likely to lead to a smaller sum by way of compensation than someone who has a lifetime of suffering.
Yes. So the way in which you would envisage their circumstances being catered for is they are within the scheme, but obviously in terms of the applicable tariff and the kind of compensation that may be payable, it may be significantly different from those who've had a lifetime of treatment.
Yeah.
Then just dealing a little more with issues about the extent to which applicants have to prove matters. And this line of questioning is not limited to questions of eligibility, but if we're looking, for example, at proof of loss, proof of causation, does that collaborative approach which you described, that supportive approach, not automatically disbelieving applicants that you've described in relation to eligibility decisions, would you carry those principles through to when whoever it is who's doing the assessment is looking at the losses that the individual may have suffered?
Yes. Clearly there are going to be areas where generally you might expect the applicant to be able to produce more information than others. I'm thinking about if there's a claim for loss of earnings, for instance, or loss of career prospects. You could start from a blank sheet of paper, but it would obviously be helpful and reasonable to expect an applicant to come forward with some information and some chapter and verse about that if they have had an employment history, for instance. On the other hand, if you're talking about the effects of stigma and social impact and so on, it seems to me you almost inevitably have got to rely, but to a large extent, on what you are told by the applicant and their immediate family about what happened to them.
And if someone, for example, describes as so many witnesses have described to this inquiry, the horrific side effects of treatment, whether it was some of the HIV treatments or interferon in relation to hepatitis C. You wouldn't expect individuals to have to go away and get their own individual expert medical report and present it to say that this person did indeed suffer those consequences.
I mean, I'm seeking, as I hope it's clear, to ensure that the scheme, as far as possible, avoids the need of applicants to have to produce things like expert evidence or legal submissions or whatever. Having said that, clearly some fairly expert questioning might be needed. This is where the proactivity comes in of the scheme, in terms of asking the right sort of questions to elicit things like what the side effects have been for a particular person, and then to set what the description is against what the medical panel has described as included in the known side effects of particular forms of treatment, which, the way I've read it, it can be terrible.
Can we then turn to recommendation 5? So we'll just look at the text of that first on page 34 of the report. So recommendation 5, bottom half of the page, is we're now looking here at the eligibility of affected persons. And we looked at the categories earlier on. For the avoidance of doubt, because I don't think it's necessarily clear from the terms of recommendation 5A, although I think it becomes clear later, that includes divorced and former spouses.
Yes, it does.
And then
well, could it be made clearer? But I mean, clearly, the implication is there. But it definitely, I intended it to include former spouses.
yes, it is, I think, clear in what you say in paragraph 6.19 of the report, but I've just been asked to check that with you. And then the other question I'm asked to raise in relation to recommendation 5A is the reference for at least 1 year. And the question is this: at what point in time would that year have to have happened? Is it?
Well, it's the purpose of having indirectly affected people is that it would have to be during a time where there is no effect. So if there was a cohabitee, for instance, who cohabited before any treatment was given, they would not qualify. And that's true of spouses and civil partners. It's a suffering everyone has shared from the point at which that suffering begins.
And then in relation to the reference to children in recommendation 5B, I'm asked to check this with you again for clarity. That encompasses those who were the children of an infected parent and are now adults.
Yes, I think my qualification is they needed to be children at the time.
And why is that? Why?
Because I believe that children have a particular category. Children, by which I mean people under the age of 18, are likely to be affected in a very particular way by living with or having a parent who is infected in this way. And I've heard stories about that.
Recommendation.
But obviously they can be adults now and be claiming for what happened when they were children.
Recommendation 5C, parents of eligible infected persons whose eligibility started in childhood. The question is this: why do parents only qualify in the event of the eligibility, the infection starting in childhood?
Rather the same as with children. The parent of a child who has got who contracts one of these terrible diseases has a responsibility for the child, which the parent of an adult doesn't. Of course, they have a close relationship and distress. They may well come within one of the other categories in that respect, but there is a particular reason, it seems to me, for parents, given their burdensome responsibilities, the one of which will almost inevitably be a sense of responsibility, often completely misplaced, that they in some way are responsible for submitting their child to the treatment in the first place. So there are all sorts of reasons why the parent of a child who's received treatment and then been affected will be affected in a somewhat different way to the understandable issues that a parent of a grown-up might have, when actually they may feel a close relationship and so on, but it's not as close as that that I've just described.
And then two further points arising out of that. If a child were infected before turning 18, but that infection was not detected or symptoms did not develop until after 18, would parents be eligible for compensation in this category?
I don't see why not.
I'm asked to point out that in some cases it may not be possible to detect the batch or treatment that infected the child, and the date of infection of hepatitis C or HIV may be unavailable. Again, that'd be then a question of perhaps looking to see what was...
Well, that's a question of proof and evidence. All I could possibly say, bearing in mind what I've just said about the reasons for parents of children being in this category, is that it would seem to me that the later in childhood all this happened, particularly if during childhood there was no evident infection or issue, then we might not be looking at very much by way of compensation should they actually be eligible for it.
And then recommendation 5D, siblings living while under the age of 18
yeah.
as a family with an eligible infected person. So I'm asked to double check with you, the under the age of 18, does that refer to the affected sibling or to both the affected sibling and the infected sibling?
The age refers to the sibling living with the infected person.
Okay. And
the reason, I heard stories about the effect on siblings of children living in a family where a brother or a sister has been infected in this way, and the impact that has both socially and psychologically on them as children.
You have not included within those who are eligible as affected persons by reason of relationship grandparents or grandchildren. Why is that?
Putting it bluntly, I felt a line has to be drawn somewhere in terms of actual automatic categories. It could be that such people might come within F, but they'd have to show that. Some would argue that I've been stretching the envelope of eligibility quite a long way anyway, and I come back all the time to where is there a strong moral case. In terms of damages, as you said, will know, we do not, as a matter of law, award damages to people who are considered to be too remote from the wrong that's caused. And some would argue that that line is sometimes too strictly drawn, but clearly there has to be a line somewhere, or otherwise we might say, for example, we ought to compensate someone who reads about the suffering of people in a newspaper, which probably we wouldn't actually want to happen. So there is always going to be a line beyond which it's not proportionate to, in terms of the moral case or the case about responsibility to bring people within it, and I've sought to draw that line as widely as I can, but I do feel that the mere status of being a grandparent or a grandchild is probably not sufficient, but that doesn't mean that you wouldn't necessarily qualify under F if you can prove that effect.
Or presumably, potentially E as well, as a provider of care.
Oh yes, or care, of course, yes.
So, for example, like a grandparent who effectively stood in loco parentis, perhaps not formally as such, but effectively was the person bringing up the child, would be more likely to fall within F
Yes.
A grandchild performing caring responsibilities might well come within E.
And the limiting factor I put in is that they did, in fact, suffer a mental or physical injury. That's the...
And then in relation to that limiting factor, the suffering a mental or physical injury as a result, what is it that you're suggesting would have to be demonstrated in that regard in terms of a mental injury? Would there have to be a mental condition as recognised in one of the diagnostic manuals? Or would it include those who have suffered degrees of anxiety, unhappiness, depression that don't qualify as fully recognised psychiatric disorders?
I think both anxiety and depression probably do appear in the manual as it happens.
But it's a question of
But
degree.
I would... It's obviously a moot point and open to debate. Clearly, anything that is diagnosable, whether it be depression or anxiety of that nature, would be included. But I was impressed by what I read in the psychosocial, I can't remember the full name of it, but the psychosocial expert report, which seemed to be very graphically to describe a whole range of suffering, of distress, around which it's quite difficult, frankly, to draw a definition. But I would personally be prepared to see if there was some mental injury which was diagnosable, then I would certainly suggest that you take into account the psychosocial impact more generally and the distress.
And then in terms of category E, the providers of care to an eligible infected person as a result of the infection, I'm asked to ask you what level of care would require to be established for a person to fall within that?
I think under the care section I've actually described that, and perhaps one might be able to go to that in due course. But I'm talking about definitely care that would not be necessary for a person who did not have an infection. So, for instance, a parent will always have obligations towards a child, but would probably not have nursing care obligations in the way you might have towards someone who has one of these infections or the side effects from treatment. So that's what I mean. But one has to take account of the fact that parents in particular, but maybe in other circumstances, grandparents, may have caring responsibilities of a general nature.
If we just pick that last point up over the page, in the... no, sorry, not over the page 73.
Yes.
The heading carers there, if we go to 6.24, I think deals with eligibility. So a person is provided personal care or support to an infected person. The care and support provided has been over and above that which they would have been reasonably expected to provide to the infected person, but for the infection and its consequences. The care and support provided has been without remuneration, except for reimbursement of reasonable expenses incurred in the provision of the care and support. And the care and support provided was reasonably necessary to mitigate the effects or consequences of the infection on the infected person. So is it right to understand there's not a minimum number of hours that have to be established, or
no,
it's a more common sense and holistical approach?
It is that, and clearly there's a de minimis. Yeah. I mean, if you perhaps given someone a lift to a hospital on one occasion, I would rather hope the scheme wouldn't be troubled with that. But certainly anything that is of substance, and that could be, an hour a day or a couple of hours a week. I don't see why that shouldn't be compensated for if it's necessary in accordance with that sort of scheme, a sort of test run.
So I note the time. Moving on to the next recommendation, so perhaps we could do that after lunch.
Okay. Well, we'll take a break now until 2 o'clock. Not everyone will have heard me say to you at the end of the earlier session, so I'll say it for everyone to hear now. You're giving evidence. You know, of course, you must not discuss the evidence you have given with anyone, nor, for that matter, anything which you think you may yet be asked about. That goes for discussions with anyone, but you can talk about anything else you like.
I will do that with delight.